This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. This is Friday, August 16th, and this is another edition of Ask a Lawyer. I'm Stuart Address. Welcome to those of you in listening range. These days, I think that includes Moscow. Today we have a guest with us, an attorney friend of mine, a colleague, co-chair of the Martin County Labor and Employment Committee with me, Dave Miklas. Hey, Dave, how you doing?
Great. Thanks for having me.
Pleasure. We're going to talk today about Family Medical Leave Act and probably try to do a quick survey of the Americans with Disabilities Act to the extent it applies really to employment law. I, as most of you who listen regularly may know, tend to represent plaintiffs, employees, those who are suing. And Dave tends to represent, for the most part, the employer, those who are being sued.
Actually, exclusively.
Exclusively.
I've never represented an employee.
I don't know. Gosh.
This should be
So
good.
you don't even know how to walk on the other side.
No, my job is to prevent problems.
All right. Yes. Every so often, I get a small company that will hire me, and you know, I think the fact that I represent employees is invaluable. But who knows? Maybe one day you'll get an employee and you'll understand how the real side, the fair side, the honorable side, the side of justice, how that feels.
I guess I knew I was walking into this, didn't I?
All right. Well,
you still have time to escape, by the way.
Yeah, that's because you're closest to the door. You can get out. All right, let's start. And by the way, folks, as always, feel free to call us with your questions, whether it's on the topic we're talking about or anything else that might be on your mind. Maybe you think you might have a case, or somebody's threatening to sue you, or you're being sued, or who knows what. But give us a call at 772-340-1590. As they say in radio, that's 772-340-1590. And we'll be happy to try to help you.
By the way, I'm glad you mentioned the area code, because more and more people are getting what they call VoIP, which is basically cable phones. And there is no identification on those. So you do have to dial the area code.
Do you have to dial one?
Yeah, we have to dial one here, now that we've gone to that.
To VoIP.
To VoIP.
Oh, we already have a call. Patricia on line one. Hello, Patricia. How are you?
Fine, thank you. I'm very nervous.
Well, okay. Why don't you take a deep breath? All right. We're not going to bite because we're on radio.
Okay.
And there's nothing that no need to worry about anything. Just tell us what's on your mind, and if we can give you some advice, happy to do it.
Thank you. I rent a townhouse in a small complex in Fort Pierce. None of the work gets done. It's starting to look more like a ghetto.
Okay.
There's trash around. The apartments have never been pressure cleaned, or at least my side. I think I'm on the wrong side of the tracks. The trees aren't trimmed. They're rubbing against the house, so there's ants and things that you have coming off of the trees. There's a mess in the front. There's tree stubs, roots that are up over an inch walking to the door, to where you have to watch where you step. It's just a mess, and every time I ask him about it, it's a couple of weeks and we'll get there.
Okay.
A couple of weeks and we'll get there. Well, I've been here 3 years and it hasn't gotten here yet. And
do you know what your lease says with regard to repairs?
there's things inside also, but it's more concerned outside right now because I'm embarrassed to even have anybody come over.
Patricia, do you know what your lease happens to say about the duty to make repairs?
Well, I've asked him whether I could have it pressure cleaned, and he said no. I've asked him about certain things, and he says no. Plus the fact that I really can't afford it.
All right. Let me give you sort of what I can. Generally, the landlord responsibilities and the tenant responsibilities to maintain premises are
his job.
Well, no, that's not true. See, that's what I'm about to say. Whose responsibility is, landlord or tenant, is found in two documents. One is typically your lease, when you have a written lease. That will sort of say sometimes in detail, sometimes not in so much detail. This is the landlord's responsibility, this is the tenant's responsibility. And the other place you'll find it is in the Florida landlord-tenant statute. Now, that does not require the landlord to do very much in residential landlord-tenant situations. I mean, they have to, for example, provide heat, which I always find is a joke in Florida. I think the legislation should have said air conditioning, but it says heat. What else they have to do is very limited. So when it comes to, you don't like, for example, the aesthetics on the outside. It's not being cleaned properly. Trash is not being removed, in a timely fashion. I agree with you. Those are things that would drive me crazy. Unfortunately, unless there's something in your lease that makes that a landlord responsibility, there's probably not very much you can do about it. Now, if there are things that are not being repaired that are fundamental to you being able to actually live in the premises, then you may be able to send the landlord a statutory notice that the premises are uninhabitable or substantially uninhabitable. But those are under very specific circumstances. Where, for example, let's say this wasn't Florida, and let's say it was, Colorado, and you didn't have any heat for 3 weeks. I would say the place is probably uninhabitable in February. And I would be telling you to send, a statutory notice, and if it's not repaired within a certain time, you have the right to terminate the lease. But in this situation, I have a funny feeling that the complaints that you have regarding what are aesthetics, and I'm not saying that's unimportant, I'm just saying, it's not, the garbage disposal doesn't work, or, there's, mold in the house, which I get a good number of calls on in Florida. You may or may not have very much recourse. But it would be very important, really, for somebody to take a look at your lease and to see what the lease says.
He is supposed to take care of everything.
Well, that's why a lawyer then wants to look at the written contract. They want to see exactly what it says and how it says it, because as lawyers, if there's going to be a claim that is based upon the promise to do certain things, we have to see the promise. So I would recommend that whether it's me and you call Cheryl, in my office at 781-8003, or whether you call somebody else, that somebody probably should take a look at your lease. And that's the first place to start.
Yeah.
Okay?
Yeah, I just, I at this point don't know. Like I said, it's a loop, one street that goes all the way around, and there's townhouses all the way around. And I said we live on the wrong side because on the other side, the trees get trimmed, the house gets pressure cleaned.
I hear you, and
that everything is done there. And on this side, we're forgotten.
And that's why I really do think somebody should take a look at your lease.
I didn't mean to interrupt.
No, that's okay.
But on that side, there's also, because a few people that I've called have told me I have to call code enforcement.
Well, but before you do that, why don't you have a lawyer look at your lease? Okay, I mean, code enforcement may be of a help, but really, I would try to get.
code enforcement won't help because somebody from code enforcement rents the townhouse
Right.
on the right side of the road.
Patricia, I think that's the best advice I can give you, and I hope try to get a lawyer to look at your lease, and tell you what your rights are. Right now, there's not much else I can really tell you.
Yeah.
But I hope I didn't bite your head off.
No, you didn't. You
All
were
right.
fine. You were very.
So you took a deep breath, and you did well. And now my recommendation is make another phone call or two, whether it's to my office or somebody else's, and try to get a lawyer to look at that lease. All right?
All right, thank you.
Have a good day.
You too.
I guess we're going to Jay on line 3. Hello, Jay.
Hello.
How are you?
I'm well.
How can I help you?
I have a question about overtime.
Go ahead. You got two
All right,
lawyers. You got two lawyers
this is-
here that may argue.
Oh, boy,
All
now
right, you guys ready?
now
We're
they're-
ready.
On
Go
behalf
for
of
it.
someone,
You got
so-
an employee lawyer and an employer lawyer.
they're both salivating over here.
All right. If you have overtime early in the week, and which is probably outside of what they normally do, it's for a friend of mine. How's that? And typically, this is the biggest complaint that she has. She's in a medical office setting, and they or where her position is, her position requires her to sometimes stay late based on conditions of mandatory analysis.
What is
I'll
her
leave it at that.
position?
She's a lab tech, so she
Okay.
ends up having to stay late. Okay,
Let me ask you
And-
something. Does she
Go ahead.
supervise anybody?
she does not.
Okay. She's just regular lab technician, one of maybe a few?
Only
Only lab technician. Okay.
Yeah.
And
Although other people are trained, she's the one that does it. So
all right, so she sometimes has to work overtime in a week. So
Correct.
your question is she not getting paid for the overtime?
well, here's what's happening. By Friday or Thursday or Friday, because she's been required to stay beyond her shift, and her shift is 8 to 5, say. They're requiring come Thursday or Friday for her to take extended lunch periods to munch up that overtime that she made earlier in the week.
All
so
right.
She doesn't get paid for the overtime.
Stay on the line if you will, because we have a follow up. So I'm gonna turn to my colleague David Miklas. David, if an employee, let's say, has hit the 40-hour mark on Wednesday, and the employer says, take Thursday and Friday off, so that the week you still have 40 hours, is there an overtime issue?
No, if they didn't actually work more than 40, then no, they don't get overtime.
And
Okay.
if in order to prevent the 40, let's say, you're told, well, take 90-minute lunches today and tomorrow. Is that all right?
Sure.
Yeah, and I would agree with that, Jay. Until the non-exempt employee who works over 40 hours, until they get over 40, the employer generally has the right to, take reasonable steps to prevent having to pay overtime. But once the employee, goes over that number, as long as they're non-exempt, and that's a whole nother story with lots of exemptions, as long as they're non-exempt, they got to be paid time and a half for the overtime.
So so I guess I don't understand exempt
Okay.
versus non-exempt. But,
Yeah, not a lot of lawyers have trouble with that.
but the circumstances are she's working beyond her 8-hour shift.
That doesn't
Every-
matter.
Not in Florida.
It doesn't matter.
No, it doesn't even matter under the FLSA, under the federal statute.
No, there's some state statutes outside Florida
Okay.
that impose overtime if you get too many hours in a
Right.
day.
I think California does that. If you work so many hours a day, you have to get overtime. But under the federal statute and under Florida law, the issue is 40 during the week. If you work 23 hours one day, you don't get any overtime for that day.
That's right.
So it's 40 by the end of the scheduled work week that
Correct.
you've agreed
Correct.
The
upon.
work
correct?
week, the work week that you are paid for.
Right.
If it starts
So
on
it's-
Wednesday,
okay.
it ends on Wednesday. If it starts on
So
Friday,
this leads me to another question.
all right.
Say she achieves her 40 by Thursday. Okay. She's worked Monday through Thursday at 40. Can she just say, "Okay, I'll see you next Monday"?
Oh no! She'll be fired. No.
Okay.
The employee can't do something like that.
Okay. How
if they-
about she does 39 hours and then she knows that she has to go into work on Friday, can she just come in for the hour?
No, she
say,
can't.
okay.
She can't. She has to do the job that she's hired to do. And if the employer wants her to work overtime, then she has two choices: work the overtime, or leave. Quit the job, or get fired if the employer wants to fire her. Generally you're an at-will employee in Florida. There are circumstances where you may have a contract and you've negotiated not to be an at-will employee, but as an at-will employee, you're essentially at the mercy of the employer. David likes that.
It goes both ways.
The only thing an employer cannot do to you as an at-will employee is violate a federal or a state statute. So, for example, discrimination, or retaliation for workers filing a workers' compensation claim, or retaliation for being a whistleblower. These are federal and state statutes that say employer cannot punish you for these things. Other than that, if an employer doesn't like the size of your ears, they can fire you because your ears aren't a protected classification. Now, if they fire you because you're a woman, then you have a claim. But
Right.
if they fire you because your nose is too big, no claim. So if they want you to
Okay.
work overtime, your choice is work overtime or give up the job.
Okay. All right. I guess you've answered the question. She's got to stick it out, I guess. I don't know.
It's unfortunate sometimes. David was going to jump in here.
Yeah, frankly, in 3.5% unemployment, if she doesn't like working overtime and they keep working her overtime, maybe she wants to look for another job.
I would hate to agree with that, but I do.
Okay. All right. All right. So staying late is required as well. I mean, based on the conditions of her employment. As what you're saying.
Unfortunately, yes. And sometimes that becomes very difficult for people in the real world. In the real world, you may have kids to get home to. There are all sorts of reasons why you may need to leave on time. Unfortunately, if your boss, as I like to say, is a jerk, or the courts like to say it's bad boss syndrome, which is not protected, that's tough luck. Your choice is stick it out or find a different job. I may not think that's fair, but it is the law.
Okay. I guess you answered the question.
All right, Jay.
I'll pass that on. Thank you very much. Have a nice
You're
day.
very welcome. Take care.
Now, is it like that in every right-to-work state?
So you use the wrong terminology. I hate that.
Okay.
Greg, I'm going to shoot you. There used to be, and David will correct me if I'm wrong here, because that language, that terminology frustrates me.
It's from Arizona in
There
the
used
70s.
to be at-will and right-to-work states. And they were essentially at-will states like we have, where you can be fired for almost anything, and a right-to-work state where you couldn't be fired except for cause. There, I think, maybe one or two states left in the country that are right-to-work states. Virtually every state in the country is an at-will state. Some states have statutes that modify the at-will doctrine so that, for example, you're an at-will employee except you can't be fired for a reason that violates public policy. Okay, Florida doesn't. Florida, it's an at-will state, pure and simple. It's probably as harsh as it gets. Now, right to work, we hear that phrase a lot. Right to work back in, I guess I'll call the olden days, where you were talking at-will versus right to work meant you could only be fired for cause. Now, right to work is really associated with unions.
Well, yeah, and this is something that is frequently commingled and gets mixed up. The way I look at it is at-will employment means that you can fire the employee for any reason, good reason, bad reason, no reason, so long as it's not illegal, which is discriminatory or retaliatory.
Right.
Right to work means the employee has a right to work without being forced to join a union. My brother lives in New York City. He's a member of 5 unions. He does audio work in New York. In order to get a job up there, he has to basically join a union. Florida is a right-to-work state, which means that nobody can force you to join a union in order to have that job.
Right, so that's within the union context of being able or being forced to join a union. But so even though in that context, Florida is a right-to-work state, when we talk more generally about the employment context, it's an at-will state.
Well,
Yep.
and you're forced to join a union in, say, Los Angeles if you wanted to work at a television station, whether it was like on my side, on the talent side, or on the tech side. Now, the tech guy, even that's different, because the tech guys, if they went over 40 hours, would get what they call golden time, which meant every hour of the day they're being paid.
Well, you see, that's because they had a union contract, and the union had negotiated very, very favorable terms to their union members. And so we're no longer within the Fair Labor Standards Act, or usually the state law that provides for a minimum wage and overtime, requirements. You're now within an actual contractual agreement that provides you better protections than either the state or the federal government does. So now if you have a problem, it's a breach of contract case.
Oh, okay.
Yeah, and if it's a union, then it's a collective bargaining agreement,
Exactly.
and there's certain avenues that you have to pursue that way through the contract.
Interesting. Okay.
All right, so yeah, the calls come in with people that are talking about right to work, and one of the first things I ask, are you talking about a union? And 99 times out of 100, no, I know nothing about a union. I just heard that Florida's a right to work state, and I said, okay, let me explain that a little bit.
You know, that other caller was talking about, he guesses there's nothing his wife can do. The first thing I thought about is kind of what we were going to cover today is, well, you know, if she's disabled and maybe she needs an accommodation, a reasonable accommodation, then maybe letting her leave at a certain time could be a reasonable accommodation.
That is an excellent point, and you know, I know from this show, since it's already half over, we never cover anything we plan on it. So
you'll be back for the next 6 months.
Let's talk about that one concept, and you know, it'll be a teaser for the ADA, maybe for another time that you might decide you want to come back if you dare venture back here again. You're right. If an employee has a disability and they need what is called a reasonable accommodation, and we can have a whole discussion about that. You know, they have to make a request of the employer, and then the employer has an obligation, Dave, to do what?
Well, to engage in an interactive process to determine whether or not there is a reasonable accommodation that can allow the employee to perform the essential functions of the job.
And what if there is not a reasonable accommodation that this small employer can make that, you know, would allow the employee to perform the essential functions of the job, but without causing the employer undue hardship?
Well, then the employer has done its obligation. And when you say small employer, the ADA, the Americans with Disabilities Act, only
15.
applies to 15 or more.
Right.
So if you have 10 employees, the ADA is not going to apply to you. But assuming that you are covered by the ADA, the employer's duty is triggered upon for two things. One, the employee having a disability and essentially notifying the employer that it has a disability. And then two, requesting some kind of accommodation. And they don't have to use buzzwords or certain key terms, but if they have a doctor's note saying, hey, Bob's got whatever, cancer and needs, you know, chemotherapy or something like that, that triggers the employer's obligation.
What if, does this trigger it? The employer sees you walking in every day for a month with a cane, but you don't actually go to the employer and say, you know, could you make me an accommodation so that I don't have to get up as often during the day? Does that trigger the employer obligation to say something to you?
No. Assuming the employee is doing their job, then actually the employer probably can't legally ask questions about a disability unless it starts to appear to affect their job, and maybe because of, I don't know, like the cane thing, they can't get around to an area they need to work in. Then the employer can ask, you know, is there something you know, that we can do to allow you to perform the duties of your job better?
And this is a good example of where the Family Medical Leave Act, which we were also going to discuss, and I guess we'll just flip around a little bit. I've always viewed it as a very unique statute that I can't believe came out of Congress. Very favorable, I think, to the employee. In the Family Medical Leave Act situation, let's say you don't go to your employer and say, my wife has cancer, and I really need some time off over the next 6 months to take her to and from doctor's appointments and surgery and chemotherapy and stuff. But let's say the employer finds out through one of your co-employees. Does that trigger anything?
It could. The employer, well, first of all, assuming that it's a covered employer, all that really matters is when the employee or the employer just on their own finds out about a covered ailment or condition, then they have an obligation to designate leave. And actually, a Department of Labor opinion letter just came out recently where an employer tried to do the nice thing and allow the employee to have more than the statutory leave, the 12 weeks of leave. And the Department of Labor is very clear that you can't hold back and not designate and let them take a bunch of leave and then go on later on and designate and give them another 12 weeks. Once the employer is on notice of a qualifying condition, they have an obligation. There's certain timelines that they have to designate that leave as FMLA.
And they have to give you the FMLA packet, which is a set of government documents that you apply for the FMLA leave.
Yep.
What I've always found interesting in the FMLA versus almost any of the other statutes that protect employees is, with the FMLA, once the employer has reason to believe that there is a covered event, whether it's because you come to the employer or, the employer hears it through scuttlebutt, in the cafeteria, once they have reason to believe, it's their obligation to provide you the packet. Now, if you don't apply for FMLA, that's your problem. But they have to give you that packet or there's a technical violation of the FMLA.
Yeah, and that's true. And if you're covered by the FMLA, private employers, 50 or more employees, one of the requirements is that you have to have it posted on the wall, has to be in your employee handbook or at least given to the employee when they start working the job. That's the notification to the employee about what to do. And then once the employee puts them on notice and they receive the packet, there's certain documents on forms. If the employee drops the ball or chooses not to turn it in because they don't really have an FMLA qualifying event, then the employer is essentially done at that point. And I've got multiple cases going on where an employee exhausts all of their PTO, all of their regular leave, either sick or vacation or personal time off, and then they're left with they want to keep taking time off. And frankly, unless it's a disability or something covered by the FMLA, and they're not entitled to any more time off, the employer can fire them if they keep taking time off that they're not entitled to. So
that's right.
If you give them the FMLA paperwork, the employer's trying to do the right thing usually, and if they come back and fill it out and say, hey, yeah, I've got a disability or, this is my condition or my family member's condition, then they're going to be covered and protected under the FMLA for an additional 12 weeks of leave. And now it's not paid unless you've got it stuffed.
Now, it's an interesting point. You say an additional 12 weeks. Does the employee have the right? Let's say the employee has 4 weeks of PTO time available. Can the employee say, I'm taking those 4 weeks paid, and after those 4 weeks, I want up to 12 weeks, depending upon whether the doctor certifies it, I want the 12 weeks of unpaid leave?
Generally, no. The employer has absolute right to force the leave to run concurrently. Any employee handbook I've ever worked on will say that. Almost every employee handbook that's written by a lawyer will run those leaves concurrently because the employer needs to run the business. They can't have someone out, 2 months of PTO that's been all built up, and then an additional 12 weeks of leave, and someone's out of the workplace, 5-6 months.
And I would agree with you. And I think then the salient point for anybody who's listening is really, if you are protected under the FMLA, essentially you've worked for the employer for at least a year. You've put in 1,250 hours, which generally you're going to do if you're full-time and even if you're major part-time. And the employer has at least 50 employees within a 75-mile radius of where you work, so you're covered by the FMLA, you can have up to 12 weeks of unpaid leave. Now, if you're lucky enough to have accrued 4 weeks of PTO time, the employer is most likely going to require you to take the first 4 weeks of those 12 as PTO and pay you, and then you're going to have 8 weeks left of unpaid time. It's not the 4 weeks plus the 12 weeks.
Right.
And that's where I know we get some calls too, and people say, well, I know I had 12 weeks, and why can't I take the 12 weeks now? And it's because you're right. If the employee handbook has been written by a lawyer, it's going to be concurrent time.
So it's on the employee then to handle all the paperwork, I guess, if you will.
Well, for the most part. Once the employer gives the employee this packet of forms, and it's not voluminous forms. It's like 4 or 5 forms.
Okay.
One is a one-page application for FMLA. The next page is a doctor's certification that you qualify. And let's say it's your own health issue, that you need 6 weeks of time. And if it turns out you end up needing more than 6 weeks, you'll get another certification. Or if it's for a family member, that cancer or what have you, was in a car accident, and you may not need a block of time, but you need what's called intermittent time. I need a day here and a day there. For the next 6 months, I may need a day here, a day there to care for, my significant family member, and it's defined in the statute who qualifies. Then you may get approved for intermittent FMLA. Now, that doesn't mean that you can just call the employer at 6 o'clock in the morning and say, I won't be in today. That still means that you have an obligation to give as much notice as possible and as reasonable to the employer that you're going to have to take one of those intermittent days off. Now, in situations where there's a significant, an emergent situation, your husband's rushed to the hospital at 2 o'clock in the morning. Well, no, you don't have an obligation to have told your employer 3 hours earlier than it happened.
That's kind of a common sense
right.
thing.
So if they fired you because you gave untimely notice, I'd say you now have a claim against the employer, because that's unreasonable. But if you as the employee were to abuse the intermittent leave by always just giving untimely notice, I would say that the employer is probably going to prevail if they terminate you.
So now you both have mentioned over 50 employees.
Yes.
What happens in a real small company? It's kind of a mom and pop, say 8, 10, 12, who knows?
What happens is I tell Cheryl, I can sexually harass you and it's not sexual harassment.
No, you can't.
Yes, I can. I wouldn't, but I can.
It's not covered by the statute. Basically, like Title VII, which would cover sexual harassment, only applies if you have 15 or more employees. The FMLA only applies except for public entities like the city, the county, a school district, which doesn't matter how many employees you have. But for a private company, you need to have 50 or more employees for there to even be coverage.
So if you have 45 employees in a company, which is an inquiry we always make in the beginning, you don't have FMLA protection. So if you need time off and the employer fires you, unfortunately, tough luck.
Wow.
And that's a statute where Congress said 50. Title VII of the Civil Rights Act, which is discrimination, sexual harassment, is a statute where Congress said 15. And the legislative history of the debate in Congress essentially discloses that the debate was over concerns of imposing an undue burden on small companies not to discriminate. Now, I think that is absolutely patently absurd. I think that, maybe, okay, come on. Nobody should do it, but 5 employees, 3 employees. I think unemployment or something is at 2 employees. You shouldn't be able to get away with it just because you're small. The FML leave I sort of understand before you start imposing that kind of a burden of you're going to be out and now the employer has to get coverage for you. I can relate to that, even though I'm on the employee side. When it comes to discrimination, sexual harassment, I don't think it should happen, period. But, the sort of teasing in my office, Cheryl's too chicken to call us right now. I know she's listening. She has to. But the joke in the office is if I wanted to, I could sexually harass her all day. There's nothing she could do about it other than leave. Now, that's verbal. God forbid I cross the line and I touch. That's battery. Yeah. So there's no sexual harassment, but it's battery.
Yeah. It could be a crime. It could be a tort.
Tort, right. Mm-hmm. And very often when people call my office, and particularly with sexual harassment issues, and I find the company doesn't have 15 employees, the key question that Cheryl always hones in on in the initial discussion on the phone is, was it anything other than verbal? Because what she knows to look for now is a tort claim to see if we have another claim that would be available. If the guy's brushing up against you, well, that's battery.
What if they're stupid enough to put it in an email?
It happens.
Are you serious?
Yeah.
I was just joking.
I have pictures of genitals that I get copies of.
Yeah, there's text messages that sink the employer's case. At the beginning, as soon as you get that, it's like, okay, yes. You got to settle this.
So let's give a good example. You represent the employer. I represent the employee. I write one of my lovely 15-page demand letters, and page 7 of that letter is a full-size photograph of the employer's genitals.
Yeah.
Okay? And then I make a comment. I said, I can't imagine why you would text this to her. It's not even impressive. So now I'm ridiculing the employer. You get that letter. The employer gets it.
Then
comes
you
over
get
to you.
sued for slander.
No, not at all. The employer comes to you with that letter, and you see the proof right there in the demand letter. What do you tell that employer?
Well, assuming it's accurate, I always verify.
You ask him to drop his drawers to see if it's his.
I'm one of the few lawyers. I want to know where the skeletons are. Is this
Right.
is she making this up, or he making this up, or is this true? Yeah, and if they say, yeah, I did that, but possibly, it was not unwanted.
Okay.
If it was not unwanted, it's not sexual harassment, because it's only sexual harassment if it's
Good point.
unwelcome.
Good point.
If it's welcome, if it's banter going back and forth, or if she's pursuing him, and I'm saying she, but obviously it could be either gender, then it's not going to be a viable claim. But things can start off as consensual and then switch at some point later on. But yeah, no, once you see something like that.
Now, you've had real cases like this?
Plenty.
Yes.
Oh, my God.
But you want to know something? When I have that kind of evidence up front,
It's going to settle.
not a single case ever gets even filed. You don't even get the lawsuit.
No.
It gets settled before there's ever a lawsuit. Sometimes you go to a pre-suit mediation, but I haven't had a case like that go even to a filing of a complaint.
No. Especially if the employer wants it quiet, because something like that, it will be sensationalized. The press may pick up on it. I mean,
Right.
it's a fiasco.
Well, another thing I do in my demand letters, I don't want to give away all my secrets.
I've gotten one, and I know exactly what you're about to say.
There is an ad I take out in the newspapers. Now, each ad must be approved by the Florida Bar. But I have a format of an ad that has been approved 5 or 6 times by now that basically says, have you been sexually harassed, whatever it says, and do you know of anybody who's been sexually harassed at this business? Bill's Onion Shop. So the Bill's Onion Shop is right there plastered in the newspaper ad. And what I'm looking for is 3 things. 1, I'm looking for possible witnesses to my client's claim. 2, I'm looking for possible other claimants that I could represent. And 3, if it's not actually in the paper yet, and I just I send them a copy of one I had in the paper for another company, and it's in my demand letter. Well, the implied understanding is this is going to happen to you too, unless we're able to settle this case.
Wow.
And a lot of times, people, when you see what goes on in the day-to-day news, when you're caught with your pants down, you tend to want it to go away and to be quiet and to, nobody ever hear about it, and very often you'll pay a pretty penny for that, even if you have to, tell your lawyer to pay somebody for you. I don't know. Where did I hear about that one? Somebody who's gone to jail recently. I don't know.
You're so bad.
I know. So all right. So we've gone to from ADA and FMLA. We've gone to overtime and sexual harassment, and that's when I love these shows, because nothing goes according to script.
But you notice that the call that came in dealt with the FLSA, which
Right.
is, even though we do labor and employment law, the vast majority, at least for me, of things that come across my desk are wage claims. It's by and far in South Florida the number one type of thing that is getting employers sued.
And the number one thing that comes into my office are at least alleged claims of discrimination. I mean, I do plenty of overtime claims, but more of them are discrimination claims. Now, frankly, for the most part, most of the calls that come into our office, there really isn't a claim. People think they have a claim, and they're certainly entitled, and they should contact a lawyer to see if they do, and that's in part what Ask a Lawyer is all about. But very often, people will call and say, "Oh, it's a hostile work environment," and well, what makes it hostile? The guy, he's always yelling at me and screaming at me and cursing at me. Okay, what else? And you find that there's no conduct that is based upon a protected classification.
Yeah, he
race,
might be
age, gender,
Yeah,
you
might
know.
be yelling at everyone.
Exactly.
Men, women, disabled, non-disabled, everything.
Exactly.
Sounds like every television newsroom I've ever worked in.
You know, so I just finished watching the miniseries on Roger Ailes. It sure sounds like that place. Fox, good old Fox. I am very bad.
You could thank Roger for selling us WPSL.
Oh, okay. But yeah, very often, I would say more than 90% of the calls that we get in our office turn out not to be viable claims. And, I don't want to take those, and diminish the value of my sending a demand letter to somebody because they hear, well, he'll send it to anybody for anything, and it doesn't matter if there's really a case there. We turn those down. And, the cases that we take in our office are cases where I believe that, some employer has really screwed the pooch.
Have you guys ever faced each other?
Our firm, in a prior reincarnation, our two firms did, but now we're both on our own, so no.
Okay.
But we often write point counterpoint for the Martin County Bar Association monthly magazine sidebar, because we both co-chair the Labor and Employment Law Committees.
Gotcha. Okay.
That's sort of what we're doing here on the radio now. It was going to be sort of like point counterpoint. Well, my position as the attorney for the employee, and we didn't really get into that too much.
I mean, at the end of the day, the law is the law. There's certain things that we can argue about the interpretation or the application of the facts, but we both know, most likely, assuming that the facts don't change, we both know where the strengths are and the weaknesses are, and that really is a benefit to having an experienced labor and employment attorney, because if there's no case there, then you don't want to clog the courts with that. And if there is one there, if you have someone on the other side, because I'm sure you deal with in-house counsel that don't know what they're talking about, and it's a case that probably really should settle, and they're going to litigate it, it doesn't really help anyone to do something like that.
No, and especially when the employer ends up paying the attorney's fees, and they're often in an overtime case, they could exceed the actual overtime owed by a factor of 100 or more. So, for example, why would an attorney like me take an overtime case for $100? It makes no sense, you would think, but the FLSA has an attorney's fees provision in it. So if I write a demand letter for that $100 and the employer settles, well, I've written a lovely letter and I may get a little bit of money, but not very much. Okay. But if the employer makes me file a lawsuit and makes me go all the way 2 years through trial, and I win in front of a jury, and the employee gets $100, which is doubled for liquidated damages to $200, and then after trial I make my application to the judge for attorney's fees, I might be getting $50,000, $60,000, $70,000. Because if the employer has made me work that hard, the employer is going to pay for it.
Right. And the first thing that when something like that comes across my desk is I have that conversation, and business owners hate that. They don't want a lawyer having that conversation up front. They want someone who's going to fight, but at the end of the day, they're not going to be happy 6 months down the road when they've spent far more paying me to defend the case than it would have been to settle it up front anyway, especially if there was a violation.
And right before we go to William on line one, let me just respond to that is I have actually had two small company clients where I was on the reverse side and I was representing them, and they got an overtime claim, and I had to tell them that I don't think it's viable from the facts I know at present, but the reality is it's such a small amount. Let's try to just get it done with. And I had one fire me on the spot, for not being tough enough, and down the road another one who didn't listen to me and ended up paying like $20,000 in me the legal fees before they settled, and paid like $3,000 or $4,000 to the employee. I never heard from them again either, and that's where we as the lawyers get punished, by the clients sometimes, but it's also what happens if you don't listen to your lawyer's advice, assuming it's competent, considered advice, and it makes sense. So anyway, we have William on line one. Hello, William.
Hi, guys. I just want to ask you a quick family law question.
Okay, I'll try.
Quick in the world of law. Got to put in a termination of alimony back in February of 2018. It's been back and forth in the courts for a long time until a final hearing in May 10th to be exact, of this year. We are still awaiting a decision from the judge.
Right.
How long do you, I know there's no statutes that holds a judge. A judge could rule on it in a year or 2 or 7. What's your feeling on this?
Wait a minute, you're both laughing at this.
Because, unfortunately, William, it's a common problem. It's a common problem in lots of divisions of the court. Family law is a very common problem because there are so few judges. You use magistrates here that make recommendations to the judge, and then the judge has to review the report and recommendation, usually to rubber stamp it, but until it's signed, there is no final order. The only way you can deal with a judge who you think is taking too long is either if you have an attorney, or if you don't, to do it on your own, is to file a motion for a status conference and bring it to the court's attention gently and diplomatically. Your Honor, this has been pending for 6 months, and we were wondering when the court may expect that a decision will come down, an order will come down. And judges usually handle that okay. If that doesn't work, then you risk offending a judge, to be honest, but you can always send a letter to the chief judge of the circuit with your little complaint, and it could get checked in on. But, as an attorney, trust me, I try never to intentionally antagonize a judge, because even though they're supposed to be impartial, and even though they may actually even try to be impartial, they are human. And if you irritate them to a great extent, you're probably not going to get what you want. Just like if my kid irritates me and harangues me too much, he ain't going to get what he wants, even if I was going to give it to him in the first place.
Who's the chief judge in our current area right now?
In the 19th Judicial Circuit?
Yes.
That's a very good question. I should know that answer, as should David, who is, I think, Googling it at this moment.
It used to be Roby, but I don't think it is anymore.
It used to be Roby, but Roby's now in Martin County,
Yeah.
and he's no longer chief judge. And it was Judge Canarak, but I know it's not Judge Canarak now.
He retired, didn't he?
I think he did, yes.
It was Metzger for a while, wasn't it?
Yes.
Was it Metzger?
She was the most recent, I think, yes.
Okay. I will tell you this, if we get the answer on Google right now or not, but it's easy enough to go to the 19th Judicial Circuit website, and it's easy to see who the chief judge is of the circuit. But if you have a situation like that, which it sounds like, I don't know if there's a lawyer involved or not, Judge Sweet, Gary Sweet.
Oh. Good guy.
But, if you have a situation like that, before you go to the chief judge, I would really file a motion for a status conference, or you might want to call the judge's chambers and speak with the judge's law clerk or judicial assistant, I guess in state court, judicial assistant. Oh, whoa. Okay. Now it looks different. Judge Lawrence Meerman is listed as chief judge.
And this is on Circuit 19's website. So I think it's Judge Merman now.
Okay. Judge Merman. No relation to Ethel.
Judge Merman was not elected. He was appointed by the governor.
Well, that's usually how it works to start out with. When there's a vacancy, the governor gets recommendations locally and picks from, I think it's a list of 3. And then when that initial term is up, you run for re-election. But the way our state constitution is, initially if there's a vacancy, it's an appointment. But like I say, I would either call the judge's chambers and speak with the judicial assistant and gently inquire if they know when you might expect a response. If that doesn't work, I'd actually file a motion for a status conference so that you get in front of the judge and can politely ask directly.
I agree that those 2 things definitely should be done before you contemplate the third.
Okay, so you got 2 lawyers giving you that advice now. What you do with it is up to you.
Yeah, well, I'm already $58,000 into this lawyer, so
right.
I guess what's another 1 or 2 for a status conference?
Well, I guess it all depends upon whether or not that 58 that you're into this lawyer for already is 58 that you think was for work that was competently and diligently done, or whether it's just a lot of money. So
Both.
okay.
So
Well,
okay.
that's a lot better answer than saying, I think this lawyer has dragged things out for 8 years. I have a couple cases like that, and where I would have given you maybe different advice. But okay.
All right. Thank you very much.
All right. Take care, William.
Okay,
Bye-bye.
could he get like a change of venue to Miami where there's more judges? It might be later the case.
No.
It sounds like it's almost all done.
Yeah, and besides, you're not going to get a change of venue, for that. A change of venue has to be for a legitimate statutory reason. There has to be some connection, let's say, of Miami to the matter to even argue for a change of venue.
Okay.
Otherwise, you're forum shopping, Greg. You're a judge shopper.
Judge shopper. Oh my.
All right, so we're down to the 2-minute warning. We're on the 20-yard line. We're trying to get ready to score that last touchdown and take us over the top. Greg is familiar with all that play-by-play. So, Dave, in our last couple minutes, representing the employer, what would you say is the most significant advice that you generally would give to an employer in an employment context to make sure that they don't run afoul of all these various laws?
Contact an employment attorney before you take action if you're not 100% sure. For instance, if you fire someone, which is what you and other plaintiffs' attorneys call the death sentence in employment law, it's the worst thing an employer can do to an employee. It's the most egregious act that they can take for adverse employment action. You can't really take it back. It's real simple to pick up the phone and call me and run a termination by me before you fire them. And if you aren't doing it right, I could fix it, or maybe we need to delay it, or we can stop it before there becomes liability. Whereas what usually happens is I get the call after you write the letter or after you file the lawsuit. We can't go back and fix any of the facts. We're stuck with what we have, and maybe the facts are really bad.
So I think the best advice for both the employer and the employee is ask a lawyer. Before you do something you might regret. And for the employee, I'll say, before you quit because of the way you're being treated, call a lawyer.
Yes.
Because a lawyer might be able to protect you before you resign. Notice quit, resign, different words. Anyway, until next Friday, when we are back with Ask a Lawyer, I will be here alone handling your calls, and maybe we will invite David back one Friday if he's willing to undergo the gauntlet again.
Yeah, this is cool.
Sure. And try to cover some of the topics we really wanted to cover. But I think we covered a good variety of employment law topics, and thank you for those who called. Have a wonderful weekend, and until next Friday, this is Stuart Address with David Miklas for Ask a Lawyer.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, webcaster to the world on Alexa and Google Home.